All right, everyone. Thank you so much for joining us today. We are going to get started. I know we still have some people coming in out of the waiting room, but to make sure we have time for everything, I am going to get us started. My name is Taylor Kohler. I use she, her pronouns, and I am the Policy and Program Staff Attorney with the Center for Human Rights and Constitutional Law. Um, I am the name that you all saw in your invite. If you have any questions after this presentation today, they can go to me. My email will be at the end of this presentation. It's also on the registration that you got and everything like that. So you can definitely reach out to me if you have any questions. I will be sending out after this presentation a recording, the PowerPoint, your CLE certificate or certificate of participation. I will try to get that out as rapidly as possible. I know this is an important resource, but if everyone could give me just a little bit of time, I will get that out. If you haven't seen it by the first of the year, reach out to me. But I will definitely try to have it out to everyone before then. Um, so that should all come over to you in an email. Um, as far as any questions today, if you could please just drop those into the Q&A. We will leave time at the end to answer those questions. Our chat is disabled for attendees, although our presenters may throw some things in there for you. They'll let you know if they do that. But your question should go into the Q&A today. And with that, I will get us started. Our training today is Habeas 101, Intro to Habeas Petitions for Immigration Attorneys. And here to hopefully give you lots of great information is the Center for Human Rights and Constitutional Law's Legal Director, Bartis Vakili. And we also have Kel White. They are the Associate Director of Public Engagement and Training at Acacia Center for Justice. I know you're going to learn a ton from them today. And with that, I will hand it over.
Thanks so much, Taylor, and thank you all for joining us. I know we're getting to the end of what's been a really long year, and hopefully we'll be able to give you some tools to help us hit the ground running in the new year after everyone gets a much deserved little reprieve. I'll start actually by just telling you all as immigration lawyers something I've been saying for years and years and years. I started as a removal defense lawyer. It was my first job, and did only removal defense for 4 years before I became a federal litigator. And ever since I became a federal litigator, while that transition was difficult in the beginning, I've been telling folks that this is something absolutely any removal defense lawyer, immigration lawyer can do. You all practice in what courts have widely recognized as the second most complicated area of law out there next to the tax code. And courts say it all the time. And if you have an ability to understand the immigration laws, navigate immigration court, and navigate immigration judges, you certainly can do federal litigation, and certainly habeas corpus, which is a very smooth entryway into this field. Just rather than having to guess what an immigration judge particular picadillos are, whether they allow certain kinds of filings or certain kind of deadlines, federal courts have rules. It's very nice. They can be daunting at first, but you have them right there, and courts follow the rules. You have judges who are generally respectful and utterly professional. You have opposing counsel who will generally be professional. These tend to be lifelong civil servants at the Department of Justice on the other side. So it can be a refreshing experience getting into federal court. And although it's been a step immigration lawyers have, I think, hesitated to take in previous years, this year seems to have opened the doors a little bit to immigration lawyers doing more federal litigation. Cal, I know the Acacia Project has tried to make this transition easier for folks. I don't know if you've seen similar success of immigration lawyers taking this step.
Yeah, it's been an explosion actually, and we're really here as a resource to help you all. I'm a good resource only because I've got a great team at the Habeas Bridge Project working and collaborating with me, as well as others on the public education team. So we're excited to be here. Yeah, and just coming into this, I'm in the same boat. I'm removal defense attorney for years. Federal litigation is new to me. So these resources were developed because I was trying to think through, okay, what would I need? What do I need?
Yeah. And so what would this presentation will be? We can go to the next slide. What this presentation will be a little bit of background of why this has become such a big deal and how important habeas corpus is right now and likely will be for the next few years at least. And then really get into like a nuts and bolts stuff. For the more complicated questions, for the more case specific type stuff, that's that we probably won't get into the details of particular types of cases too much. But like we said, the case is there as a resource. We are certainly here as a resource, particularly for qualified legal service providers. That's part of our mandate is to provide legal support for you all. So feel free to reach out on our end as well. So you can see the numbers here. If you can't see the numbers, you can see the line going steeply up. This is a shows you how many habeas petitions have been filed in San Diego. I live in San Diego. I practice a lot in the Southern District of California. Um, and you can see that since August, the number of cases filed have jumped up. This is true nationwide. I think, Kel, you track this data, right? And you know
Yeah.
there's, yeah.
Yeah, nationally, just give you some like expert immigration litigators on habeas were only filing a handful of cases last year. Like Stacey Tolchin is on record with PBS saying she filed like two per year. And so a lot of people I've talked to, it's only been a handful before this. And now, like in May this year, we were at 35 new cases per week, according to habeas docket data. Um, October jumped to 315. November, the month alone, was over 2,000. And we're now over 7,000 cases. So this is unprecedented and historical. We've backslid though, now that we have to get into federal court. But the upside is that the district court judges are ruling in our favor, particularly with your Jerry Hurtado and some of the EB cases. And you've got 45 plus district courts, according to AIC data, that are ruling for us, which is great.
Yeah. Yeah. So uh, Kel alluded to some of the reason we've got here. Yahuri Hurtado is a major part of it, but it's one piece of the puzzle. In the next slide, uh, you'll see that one of the major things that happened was in 2022, the Supreme Court issued its decision in Aleman Gonzalez. Aleman Gonzalez was one of, at the time, many class actions designed to get bond hearings for people in various forms of prolonged detention. And it went up to the Supreme Court. The district court had issued an injunction interpreting one of the immigration statutes. We'll get into it in a minute, which one, to require bond hearings. And the Supreme Court interpreted this provision, 1252, 8 U.S.C. 1252 is generally where the jurisdiction stripping provisions of the INA live. It's where Congress has tried to limit historically judicial review of various things and where us as federal litigators on immigration issues have to navigate a lot of our work. 1252 F1, the court interpreted to state that class-wide injunctive relief that challenge certain immigration statutes that restrain or enjoin the operation of certain immigration statutes, particularly the removal and detention statutes, are prohibited, that these have to go on an individual basis. We knew at the time that this was going to result in a need for individualized habeas. For those that have been doing this for a while, you might remember the days of the Rodriguez hearings, the Aleman Gonzalez hearings, various things like that. Those came out of class-wide litigation that resolved a lot of these issues. That class-wide litigation is now much more limited in what it can accomplish. And so these individual habeases have become necessary. Justice Sotomayor, concurring and dissenting, very prescient in what she predicted would happen, that district courts were going to get flooded. And indeed, combined with some policies this year, that's what's been happening. District courts are hearing so many of these cases. U.S. attorneys' offices are buried in these cases. So that's part of it. And we go to the next slide. And then obviously the detention, you're all here and you're immigration lawyers, right? The practices have changed on the ground. So those two things combined, Aleman Gonzalez and sort of these practices, Q. Lee, the practice of redetaining people who were previously out in various forms of supervision or custody, these practices are what's leading to the need of individualized habeas. Just so folks are aware, there is pending litigation from our office in the Southern District on the redetention issue. We are specifically challenging the authority to redetain people who have been released from DHS custody who are showing up for their ICE check-ins at those ICE check-ins, arguing the due process requires a hearing before such detention happens. There's a similar challenge happening in the Northern District, Garapinchi. Some of you guys are aware. We'll get into why those cases may not result in injunctive relief, and which is why individual habeas petitions will still be necessary, but those lawsuits are out there. We can go to the next slide, I think. Right, and then as Cal mentioned, Yahari Hurtado is really what set this whole thing off. This interpretation of the INA that people detained in the interior are detained pursuant to one part of the INA that doesn't allow for bond hearings, as opposed to another part of the INA that does. That resulted in a lot of these habeas cases, facilitated a lot by the templates that Acacia has put together. And then there was also class-wide litigation on that in Maldonado Bautista. A lot of you must know and be aware of at this point. Because of Aleman Gonzalez, its prohibition on injunctive relief on a class-wide basis, Maldonado Bautista resulted in a declaratory judgment. What's a declaratory judgment? Well, it's not an injunction that's just enforceable in that court. It's a statement by the court of that the law is such and such, right? So here the court says that the law is that such, class members of this class are detained pursuant to 236A and therefore bond eligible. But it was just a declaratory judgment. It still needs to be enforced on an individual basis, hence the need for habeas, which I'm guessing many of you have experienced or will soon. Immigration judges have been refusing to give bond hearings under the ruling in Maldonado Bautista. We'll come to some practice guides to help you get through that particular problem in a moment. Kel, I don't know if you have anything to add here or on the next one.
No, I think you're going to get into a little bit more later about challenging Maldonado Bautista. It was a great ruling. I think the key part and resources we want to share is that Yajira took away IJ's authority to grant bond, and now post Maldonado Bautista, great win, but in this weird world we're in now where the rule of law seems to no longer apply all the time, IJs have still refused to acknowledge it in some courts, and so you see this weird thing where they'll say it was a partial summary judgment or something like that. Luckily, class counsel has issued practice advisories and habeas templates for folks who are in that situation to address it. And I know it's courts like Adelanto, Oakdale, Chicago, Lumpkin who are experiencing this, Houston, Annandale. So yeah, and we'll go more into that later.
Yeah. Okay, so now we know why we're here. So now let's just talk really briefly about what is habeas corpus. It is literally a writ of habeas corpus translates to produce the body, corpus, the body. It's a common law right. It's existed forever, hundreds and hundreds and hundreds and hundreds of years. It's been preserved as a constitutional right and also enacted into a statute. And it basically it exists to be a means of challenging executive detention by the executive branch in our country, but even going back by the monarch, by anyone in charge of the federal government. And so it's this, you'll see it referred to as like the Great Writ, because it's at the core really of liberty that our whole country is the promise of our country at least is supposed to be based on. And we can go to the next slide. So you'll see it's been preserved in the Constitution. It's a common law right that's existed forever, but the Constitution specifically says in what you'll hear called the suspension clause, that the privilege of the writ, the ability to apply for the writ, shall not be suspended except in rebellion or invasion. It's famously suspended by Abraham Lincoln during the Civil War. That's one time it was suspended sort of writ large. Whether Congress can suspend it depends, suspension clause litigation often turns on whether there's some other means of review available. And if there is none available, then you can usually file a petition for a writ. The invasion language there is worth noting. It may be part of the explanation why this current administration talks a lot in terms of invasion, and why they couch a lot of the immigration issue in those terms. One being me, suspects that that's part of a larger plan, but right now the writ has not been suspended, and we should make use of it as much as possible. Next slide. And then the habeas authority that's relevant to immigration detention is 28 U.S.C. 2241. You see it here. There are two, if you just start Googling around habeas, you'll see two other statutes referred to a lot, 2254 and 2255. Those are specific to people in custody in federal custody, challenging, in one case, prior federal convictions or sentences, and in the other, state court convictions and sentences, and they're challenging the lawfulness of their custody. That's not what immigration habeas is utilized. So you don't want to file your cases under those statutes. It's 2241. That's the great writ that we use here. It has an in custody requirement. You can go to the statute yourselves and see it. And you basically have to argue, there's 5 or 6 maybe listed grounds on which you can file the statutory writ and win it. Largely being in custody in violation of the law or the Constitution is what we'd be arguing in these immigration cases. So yeah. So what do you do? How do you file a habeas? Well, the very first step is to understand the detention framework. You need to know what statute your client is detained in and what statute your client is detained under. We have both the INA statute and the sort of the federal code listed here. They're the same statute, but you'll hear it referred to in different ways. And there's basically 4 that govern. There's a couple more outliers, but really there's 4 that govern this. There's 3 in the pre-removal context that you see here. 236A is the one many folks are used to. So that's sort of what's always been referred to as the catch-all. That's the detention of someone on the interior of the country. The statute says they may be detained during removal proceedings, but that means they may also be released. And because the statute says that, the regulations provide for a bond hearing before an immigration judge. That's technically an ICE determination of custody and then a review of that determination by an immigration judge. That's 236A. 236C is a carve-out of 236A. So detained in the interior, if you have certain qualifying criminal convictions, you do not, then it says, mandatory custody is what you'll hear a lot. I'm of the view that there's no such thing as mandatory custody. ICE always has the authority to release under the parole statute. But at minimum, it means 236C means detained without the opportunity for a bond hearing before an immigration judge. The first one you see there is 235B, and that's broken up into B1 and B2. B1 is the expedited removal statute. So for those that are familiar, that's folks who are arriving at the border or detained recently after crossing the border. If they don't have documents or had false documents, they're subject to expedited removal. That's a summary removal without a hearing, unless they make a claim for asylum. And that sets off the credible fear process, right? So if you have a client who's in a credible fear posture, that's all 1225B, 235B1. That is also, one of these so-called mandatory detention statutes. So no bond hearings for folks in that posture. And then if you get through the credible fear interview, then you get put into regular removal proceedings. B2 is sort of the fallback for other folks that are arriving at the border and allows for folks arriving at the border to be put into regular removal proceedings. It's also one of these so-called mandatory detention statutes. So it says that they shall be detained until the removability is determined. But again, all these folks can get out under parole. That's an option, so it's not really mandatory. And the reason I say all this is because figuring out what statute applies is really part of the game here, right? The whole Yahuri Hurtado, Maldonado, Bautista legal issue is which of these statutes applies, as Kel mentioned earlier, right? So are they 1226A and therefore eligible for a bond hearing under the regulations? Or are they 1225B2 and therefore so-called mandatory custody and therefore no bond hearing? The Maldonado Bautista court said, following like hundreds of district court habeas decisions on the same issue, that 1226A applies to people detained in the interior. And B2 is limited to people who are really arriving, in the act of arriving. Kel, I don't know if you have anything else on these particular statutes.
No, and I think what's good to know is like previously I was able to get people out on parole who were arriving, but now like current data, so they're basically treating what's happening now. Yuzuri Otato overturned like 20 years of precedent and said that the 1226A folks are actually 1225 folks, and that's totally bizarre in a lot of ways, legally speaking. But federal district court judges are not buying this argument. And I think that's just key to keep in mind that there's a lot of hope there. I think what you also need to keep in mind though is like parole is really not an option anymore either. Like before, I used to be able to get people paroled out. Now AIC data, University of Iowa data is saying that less than 1% of people are getting paroled out. That's something more like 0.13%. So parole isn't much of an option anymore either.
Yeah. Yeah. Again, why habeas becomes so important. One quick sort of flag for folks who aren't aware, there used to be for people who were recently detained, arriving at the border, but crossed iwi, they used to be eligible for bond hearings under a case called Matter of XK. Matter of XK and that was for like 20 years. The immigration agencies interpreted the statute that way to require a bond hearing. Matter of XK was rescinded, I think, during Trump 1. There's litigation on that. The case is Padilla. It's a number of organizations. If I start listing them, I'm going to leave someone out, so I won't even start. But it's being litigated in Washington State. So just keep an eye on the Padilla litigation coming out of there for iwis who crossed, detained while crossing. Let me go to the next statute or the next slide. And then so for people who have final removal orders, they're detained under a different statute. It's INA 241 that covers their detention. This applies not only to people who were in custody under one of those other statutes and obtain a removal order while in custody. That certainly does apply to them. But folks in withholding only proceedings, folks who are reinstated and therefore in withholding only proceedings, they're detained under this statute too. In fact, that's the statute that was at issue on Aleman Gonzalez, is people in withholding only, largely people in withholding only proceedings. And they were detained under this statute. It's got many subparts to it, but really it boils down to this. The INA requires under A2, for the first 90 days, the government must detain after a removal order, and that's presumably for the purpose of trying to effectuate that removal order. After 90 days, detention becomes permissive, so it's not mandatory. They may detain, but they may release. And that, I think, recognizes that if it's taking longer than 90 days to effect a removal order, there may be problems with effecting that removal order. Zadvitas, which was one of the seminal cases on these issues, held that the statute does not permit indefinite detention. So they just can't hold you trying to remove you to countries and you'll never be removed. After 6 months, there's a presumption that removal is not reasonably foreseeable. And if removal is not reasonably foreseeable, then detention for the purpose of removal serves no purpose and is therefore unlawful as a matter of, it's a statutory case. They interpret the statute, but basically because it would violate due process to interpret the statute another way, they say that detention is not authorized. And so you'll see a lot of these advitus habeas petitions for people who can't be removed. Used to be a lot for, Cuban nationals, stateless folks, people from Palestine, people from Iran, people that just Vietnam that couldn't historically be removed. Um, there are, as policies and practices apply now, you're seeing a lot of people who have been released in this posture because they couldn't be removed. They were out either on recognizance or on orders of supervision. And we're seeing a lot of folks being re-detained in that posture. These are amenable to habeas. They're amenable to habeas both on the regulars advitus theory, but really on due process theories that once you've had your freedom given to you, you're entitled to some process, some procedure before you're re-detained. There's also these regulations, you see them here, 8 CFR 241.4, and that go through what the processes are for revoking an order of supervision for someone in this posture. So there's very specific processes. ICE never complies with these. So you could do a habeas for violations of these regulations. The federal defenders in San Diego have been doing these with great success. Brief shout out to the federal defenders in San Diego. Hug one if you know one. They're excellent and very aggressively defend their clients and have been bringing a lot of these cases. So those are available to you, habeas cases for those folks. I wouldn't call those folks detained pursuant to the removal period. I haven't really had to do one of these, but the removal period really is for the period immediately after detention, after a removal order. And I don't know that that statute is what applies to them who have been released because they couldn't be removed. At minimum, I think you have to show that removal is likely and imminent before detention, re-detention for folks in this posture is possible. And I know Kelp, I think, has some things to add on that third country piece, but I'll just mention real quickly, we put the Alien Enemies Act here too. Detention under the Alien Enemies Act, which happened a lot earlier this year, is not pursuant to an immigration law. So it's just a different statute. And so challenges to alien enemies detentions don't fall within one of these statutes. They just fall within the Alien Enemies Act. So it's a unique brand of case. And Kel, I know you have things to add here.
Yeah, and I'll just chime in on the AEA, that right now it's a 7-day notice from 7 days from the date of notice to challenging the habeas before potential deportation. That's still being challenged. There's oral arguments and a January on this. And just thinking about this realistically, like 7 days to find an attorney or to even like gather your evidence to file a pro se habeas petition is bizarre. And the concurrence in the Fifth Circuit did seem open to like a 21-day rule, but needed a little bit more information. But it's just thinking about even to like challenge the fact that I'm accused of being TDA, to get that information from a gang database, when you can get into a gang database based on wearing white sneakers or nail polish or something, it takes more than 7 days just to get that information. But yeah, and for Zadvitas, I mean, the main thing to think about, I was so wrong on Zadvitas. I thought it was out the door the minute they started making these third country agreements. But as it turns out, ICE cannot get its act together, thank God. And so people have been winning, like Cass Lopez out of El Torlado has been winning, like lots of you all, Sabrina Damast, have been winning these cases. And I think a key resource that I'm going to drop in the chat is actually this amazing piece that Human Rights First put together. And I'm just going to like go ahead and share this now. Um, can you see my screen with all the many links? Can you see
Yep.
it? Yeah.
Yep.
Okay. A key piece once Sparta starts explaining how to put together a habeas petition together is like knowing, first of all, when you're thinking about Zadvitas, is there a possibility that this person could actually get deported to any of these countries? And so here, Human Rights First has like linked the agreements. They've given you intel on like whether or not people are actually going. And so that gives you a good starting place when you're talking with your client about potentials, as well as potential evidence to file with your habeas. And I'm going to drop that later.
All these materials are going to be available to you by email. We're going to send the PowerPoint. The link should be there. So all this stuff should come to you. I'm going to breeze through the next couple slides because I want to get to the nuts and bolts a little bit more. But here we sort of put our heads together and came up with the 4 most common types of habeas we're seeing. You're usually going to fall in one of these categories these days. So it's again the Hurtado issue, the redetention issue we mentioned, supervocation we mentioned, and then the prolonged detention after final removal order while they try to deport you to either your country or a third country, which we've mentioned. So those are the four most common. There are others, which we'll see in the next slide. So the old school sort of prolonged detention, I've been held for 2 years without a bond hearing under 236C, 236B. You can still bring those habeases to get bond hearings. Those are largely successful. If you've had a client transferred far away, you can use habeas to get them back. If you need a client to testify in a state court proceeding, in any kind of proceeding, you can bring these sort of limited habeases ad prosequendum or ad testificandum. That sometimes is useful to know about when you have a probate, like a SIDG issue, or you need something from a probate court for a client. You can use this tool. Habeas has been used to say that detention's unlawful based on the conditions. It's a little bit of a mixed bag there. Certainly in the criminal context, Congress has tried to legislate an inability to do that you have to bring conditions claims in a different kind of case, not in habeas. It's a little bit of a mixed bag for immigration right now. Let me go to the next slide. And then expedited removal. So Congress has tried to limit the ability of using habeas to challenge expedited removal detention to 3 particular types of challenges: whether you're actually a non-citizen, whether you were actually ordered removed under the expedited removal statute, or whether you have one of these statuses that hasn't been terminated. Folks have, in the past, folks have tried to use habeas to get at the unlawfulness of particular decision-making in immigration court. For a while, St. Cyr's is one of these old cases back when Congress tried to limit judicial review altogether. And if there's no judicial review altogether, then I think that's why you were seeing habeas on merits issues. Now you get judicial review through a petition for review, so that's not available anymore. In Thursigium, it was attempted to be used to challenge credible fear findings and expedited removal findings in that process. And the Supreme Court said, basically, I'm paraphrasing here, but no, habeas is for getting in or out of custody. It's not for whether you win or lose your cases. And that's Thursigium, which I think I'm pronouncing correctly. So you see here, it's generally not 2241 habeas is generally not used to challenge the underlying conviction. I mentioned the statutes that do cover that, or the validity of the underlying removal order. It's not like a catch-all for everyone in detention. It can be, you can be creative, but really generally, if like what you have is a delay issue, someone who's in custody, but they need something adjudicated from USCIS more quickly, habeas isn't really your vehicle for that. That's going to be, a mandamus or an APA kind of claim. Nats delays, passport denials, those kinds of things are not habeas. They have their own statutes. Kel, I don't know if you have anything there.
No, I think most of what we're doing these days in this era is clearly within purview. You don't have to worry about 1252G. Like it's kind of a softball if the government's attorney throws that at you. So don't feel off your game.
Yeah, that's a good flex, right? So I'll let, the government has this playbook. They're inundated, so they're doing a lot of cutting and pasting. They'll tend to throw these jurisdiction stripping provisions of 1252 at you. They've been addressed, right? So if you're doing one of these, don't be concerned. Don't be afraid if you get that counter argument. Reach out to the various resources we'll provide you at the end here. They've been addressed time and again. 1252G gets at the discretion to do certain things, and it just doesn't cover these kinds of claims. Okay, so the procedure, what happens when you file a habeas really is what folks I think really want to know. It's governed by 2241 through 43. There's a note there to see the local rules. Here's just a general practice point for folks. Whenever you're doing federal litigation, you look first at your federal rules of civil procedure. Then every district court has its own set of local rules. You always want to look at those. And they track with the federal rules. So there'll be a local rule 17 that tracks with federal rule 17. It just adds a little bit more detail. And then once you've been assigned a judge, each judge has their own chambers rules. And you always want to, so it's always three sources you want to go for, like formatting, page limits, page numbers, little picadillos. That's all going to come from those three sources. You know where they come from. You don't have to ask around generally. Um, and so that's that note there. You're going to file a petition, right? So the petition is the main document. That will go to the court. It'll be generally ECF filed, so filed in the electronic system. The court clerk gets it and then is supposed to assign it on a rotating basis randomly to a judge on the shorthand is on the wheel. They say it's assigned on the wheel. You get a judge at random. There are processes for filing a notice of related cases. If you think there's a case that was heard in your district that addresses all the same issues, you can try to get the case related to another case. And what that does is the clerk will then take the filing, run it to that district court judge who you say is related to, and that district court judge then has the opportunity to take it or not take it. And sometimes they take it, sometimes they don't take it. Once you file the petition, the next step is that the judge is supposed, once it's assigned to a judge, the judge is supposed to issue what's called a order to show cause why the petition should not be granted, which then will trigger a deadline for a return, which is the opposition brief. It's just fancy, habeas has its own language. The return is the opposition brief. Sometimes the government will file a motion to dismiss. And that the statute says should be filed within 3 days. I'll tell you that before this year, it was routine for the return to be ordered like 21 days, 4 weeks out, which is super frustrating back in the day. Because habeas is meant and designed to be a quick remedy. This year, it seems like it's as immigration detention has picked up considerably, the pace that the district courts come at these things has picked up considerably as well. So, and I think Kel's tracked some of this too, but so you'll see some of these shorter turnarounds now. But procedurally, that's what happens. Then you get an optional, what's the traverse is what it's called. It's your reply brief. And you should get an opportunity to file a traverse, and then you should get a hearing within 5 days of that. Often these days on these repeat issues where the courts have just been dealing with it over and over again, they'll rule on the papers. So they don't necessarily hold a hearing. Kel, I don't know if you have, if you've seen turnaround times on the briefing that tracks along these lines.
Yeah, and I can share some data in the chat, but Southern District versus Central District of California, just to give some comparison, you see like orders maybe day of, hearings day of very quickly, compared to Central District where you might be a little bit more of a delay. Reports from like Michigan, it might be a while before you get an order, a few weeks. So it just depends on the federal district court. It's really important to get in contact with local practice, but local
Yep.
practitioners.
Yeah, which is great. That's a great lead in. We're going to get into what to do in terms of the district court by district court variation in one of these slides coming up. And there we go. So generally, you have to be admitted in the district court, right? So if you're an immigration lawyer, I'm in San Diego. If you're an immigration lawyer in San Diego, your district and your client's detained in San Diego County or Imperial County, your district court is the Southern District of California. You have to be a member of that district court. So you can't just file out of the blue. And so if you think you might be doing detained work, it's just a good idea to get your membership in line. Most of them are free. I think CD Cal has like a $25 charge or something. And generally the requirements are on the website. You just need someone who's a member to sponsor you usually, and then it's usually turned around in a day or two that you get your membership. If you have clients who are being detained around the country, which a lot of us are, you can't be expected to be a member of every court around the country. Most require you to pass that local state bar. And so the process then would be to obtain local counsel to sponsor you what's called pro hoc vice. So you appear for this occasion is the Latin, right? And so you're permitted to appear from the outside. You want to look at the pro hoc vice rules for each court because they're going to be different. I think in Arizona, you literally can self-sponsor. And then you see here that Colorado doesn't even allow for pro hoc vice. So you're going to want to know, you're going to want someone local to sponsor you. Pro hoc vice, it costs a little money. How do you find someone local? Well, again, Acacia to the rescue. Kel can describe what they have produced for you all.
Thanks, Bartis. And this is all just keeping in mind that the greatest weapon this administration is sort of using against us right now is transfers, And so everybody's sort of scrambling around as their clients get transferred to try to figure out where they need to find representation. And like Barta said, there's a lot of courts where you have to sit for the state bar, or where you have to have state bar before you can apply for federal. And I think the big ones to keep in mind where you have to sit for the exam, where there's a heavy detention population, is California, Louisiana, and Florida, where you're going to have to usually sit for that bar before you can then, and often those states require that you have that bar before you get into federal. So Pro Hoc Vice is one thing is we're all trying to scramble around and figure out what these patterns might look like. Um, is Pro Hoc Vice, and so what you want to do if you go to the next slide. So save this QR code, link to it, and be aware that these rules always change. Like every year, the federal courts can change their rules and update them. Sometimes for the better. Sometimes they become more permissive. But generally speaking, you have to be in good standing. You're applying for temporary bar admission essentially, and there's going to be a fee not for every time you appear, but for the life of that case essentially. And be aware that this is not for regular practice. So a lot of states put limits, such as Mississippi and Nevada, where you are limited to 5 appearances, 5 Pro Hoc Vice admissions per year. But there's, like Barta said, there's Arizona and Eastern District of Arkansas that permit you without local counsel. But generally speaking, you're going to have to be finding local counsel. Be aware what that term local means. Sometimes it means a district bar member. Other times it actually requires office within the district, such as Montana and Western District of Washington, which just makes things a little bit more restrictive. 94 federal courts, 94 different definitions of local. Just be aware. And so if you go to the next slide. And you can either Pro Hoc Vice in or refer out. And so we've created this list. It's a very informal list because we're sort of in this tsunami right now. And it was really just to help people. A private bar attorney, Melissa Shelley, helped us develop it, and we sort of added on. But we're actually at 43 states now, plus Puerto Rico. If you click on that link in the Google Sheet, once you get these slides from Taylor, you can see all 43 states. And there's usually many filers per state. I would warn you, Mississippi's only got one in there right now. I'm trying to do outreach to find more, but it's a large detention population. And then if you are an immigration federal filer, please fill out the form link at the bottom and add yourself. We're in an explosion of immigration habeas petitions right now, and we really need you in this fight. Yeah, and so now maybe transitioning over to what those filings will look like. Thanks.
Yeah, when is it time to file? So obviously you need someone to be in custody, and they have to be in custody at the time you file. In custody has been used broadly. So obviously it's someone in detention, but if someone's in legal custody, if someone's on ankle monitors or on some sort of order of supervision, that's sufficient restraint, I think, to warrant a habeas. I've used habeas for a citizen that was being held out of the country, that wasn't allowed back into the United States, saying he was confined for the in custody requirement to Mexico and not be able to get back. So in custody is broadly construed, but it matters at the time you file. So it's really important to file soon, quickly, in the district where you know that you have the person, because as the transfers start to happen, they affect you. If you've sort of established your ground at the time you file, then the transfers usually you can get your client back and have your case heard in the district you filed in. So you see the bottom there. If venue's proper the time you file, then you generally can avoid getting your case transferred to another district. Again, venue, where do you file? For clients physically detained, sort of these core habeas petitions, that's easy. You file in the district court where the place of detention is. For non-core, so for folks on OSUPs or on other forms of restraint, there's the venue statute is 28 U.S.C. 1391. It's generally where the most convenient for the parties and the plaintiff and where the events occurred. And so if someone's checking in at a particular field office, that would probably be where you'd file. So you just want to look at that statute in terms of where you file. Who do you name? The Ninth Circuit. So generally, you name the immediate custodian is the rule for most habeas. That's tricky in immigration because it's a lot of private detention centers, and Core Civic has in Geo, they don't have authority to release you. And so for a while, people weren't naming the warden of the particular facility because that's not who defends it. It's ICE who defends the case. And DOJ, the Ninth Circuit came out with a case in 2024 that reaches an illogical different conclusion that you have to name the warden. So you actually have to name the Geo or Core Civic or whoever warden of the facility your client is held in if they're in a private detention center. Um, that's the rule in the Ninth Circuit. It's circuit by circuit. The best practice, I think, is just to um, name everybody. Name the warden, but also name the field office director for your district. That should cover you. If you want to name the Secretary of Homeland Security, sure. But really have someone on the ICE side and then the actual warden of your facility.
And I can chime in because I think we've talked about this before too, that you can also just name people by title. And I
Yeah.
think like you all in San Diego actually had the former AFOD from my area, and now I'm in DC. And so like,
Brightman.
and he got fired. And so like
Right.
just recently, so like this pro tip, like use Federal Civil Procedure 17D and you can just name people by title. Like you should try to develop a list of everybody getting sued, but it kept changing so often that it was just like, or who you need to sue, that it was just kind of like
Yeah.
this is a if you're in an emergency situation, you just need a file. That's a another stopgap measure.
It's really dealer's choice. So how you name the person is up to you. So if in any case, if you can sue Christy Noem and name Noem in her official capacity. You can sue instead, have your defendant be named the Secretary of Homeland Security or the Department of Homeland Security. And it's really for legal effect, it's the same thing. It really doesn't matter. But I would absolutely name the warden on top of that as well. And we go to the next one. Exhaustion. I saw a couple. I tried to look a little bit at the Q&A. There's a lot of questions there. One was about exhaustion. Exhaustion is basically, in this context, prudential. So there's some statutes that require you to exhaust administrative remedies before you go running to federal court. 2241 is not one of them. However, courts will employ what's called a prudential exhaustion requirement. Sort of, if there's a process that exists for you to pursue, you should pursue it. And courts have the authority to kick your case out of court if you haven't. Now, what are the exceptions to this rule? Well, if it would be futile or fundamental rights would be violated to pursue those processes, then you don't have to do it. And so, for instance, in the Hurtado context or the matter of XK context, if we know that the immigration court will say there's no jurisdiction for a bond hearing, then you don't have to go, you just have to prove that in your habeas petition, allege it, demonstrate it in the habeas petition that you won't get a bond hearing. And the courts will generally forgive the prudential exhaustion requirement because it's futile. So the futility is really what you're trying to think about. The flip side is if you got a bond hearing, you might get some courts, who are trying to clear their dockets or whatever, saying, well, you got a bond hearing, you should probably appeal that to BIA as a prudential matter. And so we cited a case here where an immigration judge did that. So when you're thinking about exhaustion, do I need to even ask for a bond hearing? It's really case by case. If it's really truly futile, then no. If you want to just avoid a sideshow and ask for one and it won't like take too long to get the denial, then do it so that you can just allege it. But don't wait necessarily, a week to do that if it's going to prejudice your client, if you know it's going to be futile. I already gave you my admonishment to read your local rules. So that's what this slide is about. There are habeas corpus rules specific in Southern District and Northern District. You'll look there. Those are for 2254 habeases. So those are habeas challenges to prior convictions. They don't technically apply, but because those are the kinds of habeases federal courts are more familiar with, that'll sort of be in their mind. So it's a good thing to be aware of. They don't strictly apply to 2241 habeases. Your local rules will, but they're a good thing to sort of flag in terms of process. Those local rules will also have your rules for formatting, spacing, fonts, all that stuff. A case has got template. Again, the best thing to do is just to go to the templates that have been made, that will be made available to you and are available out there. What do you file? Here's your checklist. Again, a case is there's a link there. A case has put together a very helpful checklist for many courts. And so what you generally file is your petition. You got to pay $5. That gets triggered automatically in the ECF system. There's a civil cover sheet. That's just a form you fill out. All this other stuff is sort of case by case, court by court. So some courts issue summonses, some don't. Some courts make you submit a proposed summons, some don't. You'll just want to connect with someone local on this stuff. I'm of the view that a habeas does not require summons, but my view doesn't really matter for much. Sometimes you'll do a separate order to show cause. We'll talk about why you might and why you might not in a minute. Your application for pro hoc vice, if you need one, you got to submit that. And if you're going to proceed under pseudonym, you'd have to do that by separate motion. So remember, these are federal courts. These are open documents, open records, so people will be able to have access to them. Kel, anything there?
I can briefly just screen share the checklist just so you got it. We're going to send you all these resources, but this is the checklist that Bartis just went over. You can find it on the Practitioner Hub. Just Google us. And Taylor's going to send it, but we're the Habeas Bridge Project. And then we have a how to electronically file. And they've got great screenshots. Most local courts have great screenshots on how to electronically file to walk you through it, like baby steps. And then what Bartis just went through is the what to file checklist, which is pretty comprehensive here to help walk you through. Yeah, and I'll stop.
And I see where we're coming to time, so I'm going to, and I want to get to questions. I'm certainly willing to stick around a little bit. I know not everyone will be able to do that, but we'll try to get some of your questions. This sort of lists what your habeas petition, what the contents of your actual petition. So it's sort of your table of contents, for lack of a better word. Again, you'll see this in a lot of the templates. I don't think we need to go through too much detail here. And go to the next slide. Whether to do an application for an order to show cause as a separate matter is court by court. You should connect with folks locally. Many courts will just issue an order to show cause. You can file a separate application for an order to show cause. I've done it to sort of get the court moving if the court hasn't done it. So if I filed my habeas and a day or two has passed and nothing's come out of the court, I'll file a separate application for order to show cause, just as a reminder to get the court going. And that'll just get the court to issue its scheduling order. The next slide. And again, the reasons to file to get the case unstuck. A lot of people are doing temporary restraining orders. That's much more for much more urgent matters. The order to show cause is sort of like you're in between, right? So this is, yes, obviously pressing. It's a habeas matter. We would like it on a routine habeas turnaround. I want a week, I want to be able to do a traverse and I want to be able to brief this thing properly. You might do an order to show cause. If you're just like, this is such a cut and dry answer, this is unlawful detention, 200 courts have ruled that it's unlawful detention, you might do a TRO and try to go more quickly. So that's sort of the balance between whether you do an OSC or a TRO. You can attach exhibits. You don't have to attach exhibits. Your petition is your claim of what happened. So if you say it happens in the petition, that's what you say happens. It's up to the government to refute that. You can, to make it easier, attach things. I tend to be careful about attaching things. I've had the government say, well, you attach this negative decision, you didn't say anything about it, so you basically adopted it as true because it's like the complaint is a party admission. It's sort of a nonsense argument, but to avoid sideshows, I tend to allege things and not include exhibits unless I think it will be helpful to the court. So sometimes the IJ decision on a bond hearing will be helpful. Sometimes the conditions on an order of supervision will be helpful. Certainly declarations, things like that can be helpful. Anything else there, Kel?
No, this slide is key that you're on right now.
Yeah, yeah, right. So don't let the perfect be the enemy of the good, as my old legal director used to say all the time. Um, get your thing on file. There's templates out there. Fix it later. If something's urgent, um, go to these resources that we're going to provide. Plug your thing into the template that feels closest to your fact pattern. Certainly, you have to, you have ethical obligations. You have to allege things you believe to be true, but like get the thing on file and fix it later. There are forms available on most websites. You see AO 242.
Yeah.
Um, so, Cal, you can.
That's a pro tip because some courts actually only want the form and not the traditional brief in the same way. And so just be aware of that. I think one expert said that Houston is one. So just be aware, make sure you know what they require.
Go to the next slide. And then service, again, this is going to be district by district. So you have to serve federal filings on the government, and there's very specific rules for how to do it. Um, in a normal case, you would wait for a summons to issue, then you have to serve the complaint and the summons pursuant to Rule 4I on the federal government. And it's that there's like it's sort of a complicated rule, but basically you can certified mail to every agency and the Attorney General and the local U.S. Attorney's Office. Habeas is a little bit different. It's a different kind of case. Some are district by district and some are judge by judge. There's one judge in the central district that issues a summons and wants it served pursuant to Rule 4I. In many districts, just by filing it, it gets into the inbox of the U.S. Attorney's Office, and the U.S. Attorney will accept that as proper service of the habeas petition. As a practical matter, what I would recommend is you file the thing, get contact information for the civil division of the U.S. Attorney's Office in that district, and email them. Email them a copy. Get their email address and email them a copy of everything. They haven't been fighting service that I've seen, and so just really this is about fairness, right? They should have an opportunity to reply, so you just got to get it to them. Anything on service, Kel?
No, I think follow the local rules, but some of the local practitioners have great knowledge and some of them just e-serve, I notice. Um,
Yeah.
yeah.
Yeah. And then I think post-filing, again, you're in a world where you have Department of Justice lawyers who behave professionally. If you're coming out of removal proceedings and you're used to dealing with the Office of Chief Counsel who never gets back to you, it's just going to be different. They're buried, the U.S. Attorney's offices in these cases, but they really do try to get back to you and try to, they're going to zealously represent their clients, but sometimes you can work with one and get your client out of custody. So be professional. Stay in contact with them. Once you filed your case, ICE is a represented party, so really you got to work through the Department of Justice lawyer um, on these things. And finally, the slides. Oh, attorneys' fees and costs. Just really briefly, um, how do I get paid on these cases? It's hard. It's hard to win fees against the federal government. You have to find a statute that allows it. Equal Access to Justice Act is the statute that would apply here. You can get fees if you get a judgment in your favor that alters the relationship between the parties if the position taken was unreasonable. So there's a series of steps you have to file. I would suggest keep good records in case you're able to get those fees. There's a circuit split right now in whether EJA fees are allowed in habeas. In the Ninth Circuit, they're allowed. The bigger obstacle is practical. Often these cases resolve, they moot because the client gets released before you get to a judgment. And then trying to get a final judgment that's not a dismissal as moot is tough, right? Because courts are going to say dismiss it because it's moot. And if it's dismissed as moot, you don't have the judgment necessary to get your EJA fees. So there's creative ways around it, trying to litigate for more than just the habeas release, but that's a resource question for your own office, right? Am I willing to do that just to get the fees? So the next couple slides, we won't go through them. Well, I'll let Cal go through them. I mean, there's just so many resources that have been pulled together on this stuff, and you'll get it in your PowerPoint when it's emailed to you.
I'll just very briefly just walk you through habeas dockets. It's sort of like the thing that I hope puts us all out of business in a certain sense of like templates, but like you can, for the American democracy, this software engineer created this site and he's pulling all the filings, which you have to send people physically in person to gather. and has uploaded all the habeas filings for the 94 district courts onto this website. It's a really easy search to like go in and I can search, Zadvitas in, sorry, I can search like Zadvitas in, EDCal or District of Arizona. You can type in those words and it'll usually pop up. Um, and so just as a key neat way to start to find filings if you can't find a template on point. Um, and then, so definitely check them out. They also have organized all the the Administrative Office of a Court filing forms for all 94 district courts. And if you sign up on the volunteer sheet, they'll probably share them with you. And the next slide, I know we're over time. I'll just speed through. Acacia Center for Justice, we've got our practitioner hub that I just shared with you. It's a key resource. If you have a filing checklist and you modify it for your jurisdiction, please feel free to send it to me and I'll post it and give you credit. National Immigration Project has a pro se filing packets. I would click on that because it's a good way to see how pro ses might file and an easy sort of intro. RFK Human Rights, for those of you challenging OSEP and redetention, I would definitely check them out. They've got a great template embedded in that's been created for the national audience. National Immigration Litigation Alliance, they're key. Bookmark this page, like bookmark all these links when you start to do case by case representation. And you can use all these templates. The bottom one, Two Guys, a Dog, and a Habeas Petitions is really like a podcast on your way to work. Turn it on. They go into a much deeper dive than we went into today. On like Pro Hoc Vice, each segment is about 20 minutes long, and you can just listen to it in background. And there's some cute dogs. If you go to the next slide, we could all use some cute dogs right now. Yeah, next slide, American Immigration Lawyers Association, if you're not already a member. If you want to volunteer and have a mentor, Massachusetts Law Reform Institute has a program where they pair you up, much like our Habeas Bridge program, where you can get templates and be mentored to learn this stuff. Maldonado Bautista resources are there, and we pasted them in the chat. If you are new completely to detention, there's a legal access guide just on how to navigate those resources. And then finally, case tracking. AIC has these for Yajiri Hurtado Maldonado Bautista has this great every judge and how they're ruling on Yajiri Hurtado. So check that out. Great resources. And then there's many groups coming up with more resources on SIJS litigation and the detention of SIJS beneficiaries.
And then you want to mention about the mentor. I mean, I think for a lot of folks, it helps to the idea of having a mentor on
Yes.
habeas work.
Yes, and I don't want to overpromise because we can probably accept maybe 3 people in our next round. But if you fill out this form, we are looking to mentor people who are specifically practicing or in licensed in Southern District and Central District. And then if you're in Eastern District of California, you want to email this address. They are setting up a pretty robust program as well and have funding. And they've got CGA standing orders there where the federal defenders is actually able to mentor and people are able to get paid through sorry, what CGA, I forgot what it stands for.
Criminal Justice Act.
Thank you. And so you can get funding that way to do this work. So lots of things popping off, many programs. Keep an eye out to what Bardis is doing in his team and what Acacia is doing because there's more mentoring coming your way, I hope. Yeah.
So that's our contacts. Taylor's going to come on and invite you to reach out. I'll just say, yeah, I know we've ran over time. I go long sometimes. I apologize, but I'll stick around certainly to try to get through some of the Q&A.
And I'll just add for everyone, this is recorded. So if you have to drop off, but we'll take some Q&A. I believe both Bardis and Cal, maybe Cal, have time to stay and do some Q&A. So we'll answer some of those questions, but you will get the recording so you can hear those Q&A questions that way. Again, I will send out a follow-up material. And if you don't receive it within 2 weeks, please reach out to me. But I'll try to get it out as soon as possible because I know these are needed resources and we had so many links. All those links should work. We'll send all the templates and everything for you that was linked in here and that Cal and Bardis discussed. So with that, do you guys want to switch to some Q&A?
Yeah, I see a couple that I can take right off the top, and I don't know if you've been able to sort of like.
I have been moving with you, so if you see some that you want to start answering, let's go for it.
So just a bunch of the questions are like, can I file a habeas corpus in this context or in this context or this other context? Remember that the writ exists as a matter of constitutional right. If you have a client who's in custody and you think the lawfulness of that custody is in question, you probably can file a writ. And there's certainly no harm in trying. So, my client's post-voluntary departure still being held because they're not affecting the order. You certainly can file one. Just you have to think practically about what's going to happen if I file one. Is it going to hasten the removal? Maybe. Is that what my client wants? Because that's better than being in an immigration prison? Maybe, right? So it gets very like case by case. What's the best situation for your client? But that's an avenue. There was a question about UCs and this like sort of refusal to release folks to sponsors. There is pending litigation on that. You can file habeas for kids in custody, but I think really the issue for the sponsors is that the sponsors, they're worried about coming forward because of their perceived risk of detention. And so I think it's not a legal problem as much as it's a practical one, but certainly you could. There is also just flagging for folks who represent UCs. There are what used to be called the Lucas. This came out of one of our cases as well. Lucas hearings, which are now established by regulation, where you can challenge step-ups or forms of custody for kids in custody through an administrative process. And that might be your better, more user-friendly way to get at some of this stuff for the UCs.
Bardis and team, Taylor, Karen, thank you so much. I've got to hop. And just to everybody in this room, thank you for this fight and for fighting. There are helpers everywhere. So just reach out. Bardis helped edit some of my documents when we were putting them out. So just reach out. We're here for you. And good luck and keep fighting.
Thanks, Cal. And she should be here to hear this, but we've told her they've stood this project up on the fly and really done a great job. And it's just like the demand is so high that they're constantly tweaking it, constantly improving it. So, if you looked at it in August and you were like, oh, there's only 2 or 3 templates on here, you should go back on there. There's so many resources available now.
I see a good question here, Bardis, that says, how do you figure out the basis of detention for your client?
Yeah, you have to know the procedural posture they're in. So it's sort of dictated by are they in active removal proceedings? That's one. Well, then you're probably in 236A or 236C land. Right? Or were they detained while arriving in the country? Well, then you're in 235B land. So you sort of start to categorize it based on the manner of entry and the nature of the proceedings. And then from there, it gets a little bit more nuanced, right? So is your person 236C? It depends on the statute of conviction, if there's a conviction. It's really it's really diving into the INA and understanding the procedural history of your particular client. If you're in withholding of only proceedings, that's a different posture. It's not 240 proceedings. So it's really just knowing the procedural posture of your removal case and how your client arrived. There's a lot of sort of detailed to specific questions on can you go into more detail on argument for this particular posture? I'm not going to do those now. Taylor's email is there, particularly if you're a QLSP, but we do this for anyone. Feel free to reach out with technical questions like that. There are resources for all this stuff. The Acacia Center's templates probably have a template for your particular posture.
I see one question, Bardis, in addition to what you just said, asking is there any chance of essentially doing a habeas to get someone back if they've been transferred? I imagine you'd want someone back in a venue that's more favorable, or are we really stuck with that? Get it done.
So venue attaches when you file. So if your venue is proper and then your client was moved, yes, you can work within your lawsuit to get your client back. And most district courts will order your client back. In fact, most U.S. attorneys will just get your client back. If, on the other hand, you haven't been able to file and then your client is transferred, that's going to be much, much harder. You're going to probably have to file the habeas in that district. So if your client's sent to Louisiana before you have the opportunity to file, um, then that's going to be harder. So like if your client's detained, like apprehended or detained, at an ICE check-in locally, and you think they might get sent, I would just file the thing. Just get it on file, get the most skeletal petition on file, and then you can amend it. And then, but getting it on file and establishing venue in the favorable district is really key. And so it's like speed matters more than elegance, I think, at that point. There one specific question about which statute applies to your client if they're on appeal. Generally, if they're on a BIA appeal, it's going to not be the post-removal order statute. You're still going to be in 236 land. If you're at a petition for review and you have a stay of removal, you're still in that, you're not in post-removal order land either. So the appeal doesn't actually change. These days, the way the courts are interpreting it, the appeal doesn't change your statute until you have a final removal order, which is once the Ninth Circuit or once the Circuit Court has ruled or once the BIA has ruled and you haven't done your PFR.
There's another good question in here asking about strategy for if the government does request that extension of timeline for good cause, things that extend. Are there any strategies to move things along?
No, the TRO is the strategy. So file a motion for a temporary restraining order if you think it's so urgent that you can't wait the 21 days. The burden's going to be on you to prove that it's urgent, and often, the harm of immigration detention, if you articulate it, might be enough to do that. There's a good case in the Ninth Circuit called Hernandez. We can give you the site. I don't have the site off the top of my head. That's about that a money bail in the immigration context has to be something the person can actually afford. But there's really good language in there that immigration detention is just inherently harmful because of the family separation it causes, the loss of jobs. And so those are the kinds of allegations you'd want to make to justify a TRO, which is then the fastest way into court. I see a few questions on the voluntary departure question. I didn't know this was a thing that was happening, but generally, if you have a client who's taken voluntary departure and they still haven't sent the person, I assume that's a problem of like they're waiting for a flight. And you're just better off, I think, working with ICE. But if it really becomes indefinite, then I think that's like it's similar to a Zadvitas habeas petition, try to get them out. The flip side is they may respond by just fast forwarding their actual removal. I'm sort of scanning through. I wonder,
I know
Karen,
I'm
if you were
scanning.
to.
There's a lot. You guys put in over 100 questions. You did well. I do see a bunch of questions on templates and links, and while they're up on Zoom, I know you can't link through to them. I will be sending out the PowerPoint. I will double check that all those links are working, but I also will link them in the email. I'll provide PDFs of some things. And if for any reason you find that a certain link isn't working or there's a resource we mentioned that you don't see in my follow-up, please feel free to directly reach out to me. We'll make sure to get that to you. But yes, we will link all these resources that have numerous different templates and more resources within them.
If there's a template that you're looking for, I'm seeing a request here for a template for a request for a template for a writ ad testificandum. If there's a resource that's not out there, reach out to us and we'll try to track one down. I know I've seen one of these, but if it's not on the Acacia website or one of the many, many links that's on the last two slides, reach out and we'll try to find you one.
I don't know if you see any more in here, Bartis, you wanna try to tackle. I know a lot of these will be answered, I think, with the templates and resources that we're sending out, but are there some more you see?
What is the recourse if ICE physically removed your individual and deports them on an old removal order while the TRO is still pending? Generally, if you've gotten your case filed, my rule is if you've gotten the case filed and the person's in the country, you can try to work within that case to get your client back. You might have to win your case, but I've seen it done successfully. Stacey Tolchin has done this successfully. trying to get clients who are wrongfully deported back. It's a tall order. It's a tall order asking a federal judge to do that. It's a tall order. The limits of what a federal judge can do and order the federal government to do at the border is tough. These are tricky issues, but you should, if you've got your case pending, not just give up on it because they removed your client while it was pending. You should keep fighting it. And then in terms of like these local questions, so the rules for filing, what's on paper, like the spacing, all that stuff's going to be local ruled by district. So the district court will have its own website with local rules to give you that stuff. The templates should be on though. So Cal does a good job of make sure the templates are accurate and formatted correctly. So there's a lot of formatted questions here. Same like how do you know who your immediate custodian is for some random place in Louisiana? Again, I would use the resources to try to find local counsel and someone who's done a habeas and the resources in what we're sending should give you some people to reach out to. If they've signed up for that and they want to be reached, they're saying reach out to me. So reach out to them, ask who the warden is at Jenna or whoever, wherever they might be detained.
I see another repeat question. Bart is asking, at what point do the clients actually get released? If this all works, where is the release and when does that happen?
So if you win a writ of habeas corpus, so the court awards the writ of habeas corpus, it will generally command release that, generally that day. It may give some, within 48 hours. It's going to be court by court. If you think it has to happen that day, and you get an argument, you want to be specific about that. But as soon as you get that order, the first thing you do is you contact the U.S. attorney in your case. You don't want to deal with ICE. You've had enough of calling ICE deportation officers and not getting called back. Call the U.S. attorney, say, hey, the order just came in. Can you confirm when my client is out of custody? They will generally try to get your client out that day. I've never seen it last longer than a day. So if the order comes in late at night, maybe the next day, but generally they should be processed out that day. And then where the processing happens is going to be, it changes. In the Southern District, they'll take them to the trial, the public transportation here in San Diego. Some places, just like in Imperial, they'll just like take you to the bus station. Sometimes they'll just like walk you out the door. So again, the U.S. attorneys tend to be pretty professional. And if you need those details and you don't know them because you don't practice a lot in that particular detention center, then they should be able to help you with that stuff.
I see another a few that are consolidated, but asking kind of how successful are pro se petitions. Specifically, someone noted like in a district court where they can't file in as pro hoc, what is the likelihood of success of doing it pro se and can they ask for counsel to be appointed in a situation like that?
Great second. So the first question is, if it's one of these like template ones that's a lot like, the district courts now are seeing a lot of repeat types of cases. And so I think those can be successful because the court will have already dealt with, does Yari Hurtado apply here or is it unlawful, right? So that's a repeat issue that the court will have seen. I've seen those succeed. The prolonged detention habeas I've seen succeed pro se back in the day because there were so many of them. So I've seen it. I do think asking to be appointed counsel is useful and worthwhile. Cal mentioned that there are some districts where they're making CJA funding available. So this is Criminal Justice Act funding. The funding that supports appointed counsel in criminal cases, that same statute is being used to fund some of this stuff. So it's worth doing. It's going to be district by district whether the court wants to appoint counsel. It's very much in the district court's discretion whether to appoint counsel, but people should ask 100%.
The scroll through questions.
There's a lot of this, like, how do you join? None of this is, hey, Acacia's network is open. So you should just go to the links. How do you join the Practitioners Hub? It's going to be linked in the materials. Let's see. Have I seen U.S. attorneys open to stipulate? I have. I've seen U.S. attorneys. The U.S. attorneys are buried in this work. And so if they see a case that they're clearly going to lose, they've lost 15 times already, it's worth asking them, can you just cut my client loose? What we're hearing a lot now is ICE, they'll say to you, my client, aka ICE, is taking the position that release is not appropriate. So they're signaling to you that they would if they could, but ICE is saying no. But it's worth asking. The U.S. attorneys do have some wiggle room, um, and every field office has a different culture. Every ICE field office has a different culture, and certainly every U.S. attorney's office has a different culture. So it's worth 100% just reaching out. The worst thing that happens is they bark at you and say no, but that's fine. There's no harm in asking at all. Would the government consider just releasing my client rather than litigating the habeas? It's worth doing.
There's another question on here about how do you follow up on EJIA fees? Essentially, if you do get a judgment and you would be eligible, what does that process look like?
So there's a time limit. So you have to get the judgment. The way a case ends, um, you get a ruling, and then at some point the court issues a judgment. Every piece of civil litigation has to end in a judgment of some kind. Once that judgment is entered, if the judgment materially altered the relationship to your client's benefit, then you might be eligible for EJIA fees. And there's a time limit within the EJIA statute. I forget what it is, to be honest. But the statute is going to be in our PowerPoint materials, and it's going to be in there. There's a time limit, and you just file a motion. And that motion usually has to include arguments about why the government's position was unreasonable. And then your billing records. So you have your detailed billing records. And then you have to sort of state what your rate is and justify it. So, you can generally do a little bit of Googling to find your a market rate that's based on how many years out of law school you are. If you really want to put together a strong habeas EJIA petition, you get experts and those kinds of things. But for your run-of-the-mill habeas, I don't know that you necessarily need to do any of that stuff. The EJIA rate actually is, I take that back. EJIA rates are statutory. So you're generally getting about $200 an hour. And you don't have to justify your rate. So you should ignore the last thing I just said. Market rates are for a different kind of thing.
There's a follow-up question. Does a preliminary injunction count as a judgment, or does the judgment need to be on the habeas merits?
Yeah, you're getting to an evolving area of law. So for a while, the preliminary injunction was being interpreted as sufficient. And I think the Supreme Court came out with a case last year that said a preliminary injunction that eventually gets mooted out before judgment is not sufficient. And so we're in a little bit of another region in terms of TROs and PI and preliminary injunctions, whether they alter the relationship. It's worth trying, but it's going to be a mixed bag. It's an unsettled question that might be trending in the wrong direction. The way I think the best way to sort of try to preserve a right to EJIA fees is to try to litigate beyond just the habeas. If it's something you want to do, litigate beyond just the release and try to argue about, try to get an order that forbids redetention, right? So your client will be released and won't be redetained. It may not be redetained, absent whatever change in circumstances. That should result in a judgment at the end of the day. You'll win TRO, but before that case ends, you should get a judgment in your favor rather than dismissing as moot. If you dismiss as moot, you're not going to get EJIA fees. If you want to fight to judgment, then you should get EJIA fees. And that's one reason to try to fight to judgment. But it's, you're briefing, it's time. So is the time worth it? You're going to have to brief it. You're going to have to brief attorneys' fees. So these are just sort of questions of one's own resources.
All right, last one, Bartis, and then I think we'll wrap it up. Unless you just want to keep going forever. But one other question on here, it says if a client is detained by ICE in a jurisdiction that doesn't have an ICE facility, so some of the places where those don't exist, can you still file a habeas in that jurisdiction if you can do it before the client leaves the jurisdiction?
Yeah. Yes. So, right. If your client is taken into custody and is being held in what, one of these little like temporary holding facilities until transfer. If you can get that thing filed, that's where then your venue's proper. So even like your client's held in the port of entry at the airport for a couple days before being transferred to wherever or being deported, you can file there and you're good. So you don't have to wait for them to land. The tricky bit is figuring out where your client is because sometimes they'll disappear into a black hole and you can't find them until they land on the ice locator. But so I recommend to all my clients, you know, memorize my phone number, call me whenever you get the opportunity, call someone you love to call me, try to pay attention to where you're held because sometimes people don't know where they're being held. Um, any information to give me so that I know where you're being held so I can file the thing before you're sent somewhere else.
All right, the follow-up to that just came in live is in that case, would you list like the county jail as a party for those like
For the names,
yeah.
yeah. So if it's like an ICE field office, then you're just naming the field office director. If it's in a county jail, then yeah, you would name the warden of, if it's someone coming out of custody who's then going to be sent, but is on an ICE hold or something like that, then yeah, there's no harm in naming everybody. And so just name the warden and then name the field office director or literally the generic, ICE field office director for this district, and the Secretary of Homeland Security just to cover all your bases. And that way, what you want to avoid is becoming a sideshow. You don't want your case to be the bar exam, right? So like, why force the court to deal with the question of whether you name the proper person? Just name everybody. Um, as long as the one of them is correct, then you're good.
All right. Well, with that, I think we will wrap up. Um, Anything else, Bartis, you want to add before I do that?
No, just like how to get involved, links to Acacia's materials where you can sign up for mentors and things like that. I think it was Kel dropped some stuff in the chat, and we'll make sure we get it all out to you, and it should be on Acacia's materials too.
Yes. So I will send out a follow-up email. You'll have access to the recording. The recording will also go to our website. You'll get access to all these links and these resources. If for any reason you're still looking for something that we talked about, please feel free to reach out to me. And with that, thank you so much, everyone. Thank you, Bardis, and wishing you all a good holiday season.
Thanks, everyone.